Slam dunk, are you ready to meet me? I'm here and I'm riding the fast lane. Don't let me down, I'm on fire. Does anyone else feel like a liar? It's all in your head and right. You just never use it.
Canadian Bar Association courtroom is now in session. We would like to acknowledge that we are speaking on unceded territory of the Algonquin Anishinaabe people. We speak today while paying respect to the traditional knowledge keepers of the Algonquin peoples and all Indigenous peoples in the region of Ottawa who call the national capital their home. If you're not located in Ottawa today and do not know about the traditional territory on which you're located, we encourage you to navigate like websites like nativeland.ca to find out. And we also encourage that you learn more about decolonization by consulting the TRC calls to action as a starting point. It is with great honor and privilege that I present Justice Marie-Ève Casey, Justice Daphne Jarvis, Justice Dr. Jennifer Jones, Justice Tanya Pagliaroli, Justice Dr. Preeti Dar. On October 19, 2021, after battling COVID-19 for 18 days, Kyla Stark died in the ICU ward of Fallview Health 13 hours after her transfer from West Valley Memorial Hospital. Mr. Stark's medical records reveal she was in perfect health and she had no previous existing medical conditions, nor any prior family medical history that would indicate otherwise. She was double vaccinated as of August 1st, 2021. On October 1st, 2021, Mrs. Stark tested positive for COVID-19 and contacted her longtime physician, Dr. Sophia Strange, and obtained a prescription for ivermectin. Though all pharmacies in her area were out of stock, Mrs. Stark's condition was stable. On October 5th, Mrs. Stark was notified that her local pharmacy had just stocked ivermectin and her prescription could be filled. But that same day, Mrs. Stark had developed severe shortness of breath and mild hypoxia and was admitted to the defendant's hospital, where she was placed under the care of Dr. Myrtle Papadopoulos, a third-year medical resident. Mrs. Stark immediately requested that Dr. Papadopoulos administer the ivermectin her family physician had prescribed, a course of treatment which he chose to reject. On October 6, Mrs. Stark had moved into the ICU and was placed on a nasal cannula during the day and a BiPAP at night. Mrs. Stark was treated with the hospital's COVID-19 protocol, which consisted of dexamethasone, 6 milligrams IVPO, Q24 hours, and pure oxygen. On October 7th, ivermectin was administered after Mrs. Stark's family pleaded with Dr. Papadopoulos. Within 11 hours, Mrs. Stark's condition has improved greatly. However, supervising physician Dr. Leutier chose to withhold any further administration after being informed that Dr. Papadopoulos' use of ivermectin. On the evening of October 8th, Mrs. Stark's condition worsened and she was sedated, intubated, and put on a ventilator. Almost immediately thereafter, Dr. Leutier was contacted by Dr. Strange, who strongly requested ivermectin continue to be administered in addition to MATH Plus protocol. In response, Dr. Lutze asked Dr. Strange to forward him the relevant literature for which she was relying on so that he could make a rational and educated decision, which was provided immediately after Dr. Litzier determined his time would be better spent attending to his patients than reading what he referred to as propaganda. On October 10th, ICU nurse Dolores Patel was convinced by Mrs. Stark's family to speak to Dr. Strange over the phone. Dr. Strange pleaded with Nurse Patel to administer the frontline COVID-19 Critical Care Alliance Math Plus protocol. Nurse Patel spoke to the attending physician, Dr. Andy Park, and convinced him to undertake Dr. Strange's request. Within 15 hours, Mrs. Stark's ventilator was turned down, and Dr. Park and hospital personnel began the process of trying to bring her out of the medically induced coma. On October 11th, Mrs. Stark's condition had improved, at this point, having only to rely on nasal cannula. On the morning of October 13th, Mrs. Stark's family was informed by Nurse Patel that the hospital had misplaced the ivermectin, but there was no need for concern as Mrs. Stark was making great progress. However, Dr. Lutze once again assumed of care of Mrs. Stark, and upon learning of the patient's treatment course, chastised Nurse Patel and the medical staff for administering the Math Plus protocol. Dr. Lutze then administered remdesivir to Mrs. Stark. Nurse Patel phoned Mrs. Stark's family and informed that Dr. Lutze assumed care and denied any further administration of the Math Plus protocol. The family was unable to reach Dr. Park, who was volunteering in Sudbury as a part of an initiative to help provide critical care to patients battling COVID-19 in rural communities. At 1:27 a.m., Mrs. Stark's oxygen level began to drop and she became unstable. Within 3 hours, Mrs. Stark was again placed on a ventilator. The family arrived at the hospital but was denied access due to the hospital's COVID-19 protocols in place. Mrs. Stark phoned Dr. Strange and pleaded with her to get involved. Dr. Strange placed several phone calls and emails to Dr. Lutze, but after 4 unsuccessful phone call attempts, decided to drive down the defendant's hospital and attempt to manage the situation in person. Upon her arrival, Dr. Strange was too denied access to Mrs. Stark and was unable to speak to Dr. Lutze. Within 6 hours, Mrs. Stark's chances of survival had dropped to 20%, and Dr. Lutze informed Mr. Stark that he had exhausted both his course of treatment and COVID-19 protocol in treating Mrs. Stark. Mr. Stark pleaded with Dr. Lutze to administer the Math Plus protocol and offered to sign a release releasing Dr. Lutze and the hospital of any of its agents and parties acting on its behalf from any and all liability from administering the Math Plus protocol to his wife. However, Dr. Lutze refused to administer the Math Plus protocol, and a verbal confrontation ensued outside between Mr. Stark and medical staff, and security removed him from the building. On October 19, Dr. Lutze agreed to the transfer of Mrs. Stark to Fallview Health, where Dr. Strange was on staff and would therefore be able to assume care for her. However, less than 1 hour after arriving at Fallview Health, Mrs. Stark died. In this matter, the questions at issue are the following. Issue A, standard of care. What is the requisite standard of care for medical negligence in Canada as correctly applied to this case? Number 2, did Dr. Lutze breach that standard of care in A, failing to investigate the literature he was provided with, and B, denying Mrs. Stark treatment with Math Plus or ivermectin alone? Issue B, causation. Did Dr. Lutze conduct, cause, or contribute to the harm or injury Mrs. Stark sustained? And lastly, vicarious liability. Is the hospital vicariously liable for Dr. Lutze's action? Justices of the panel, I present to you, speaking on behalf of the plaintiff, Mr. Stark, in today's matter before the court, Tanya Sleman and Gia Hwang. And speaking on behalf of the defendant, Dr. Lutze in the West Valley Memorial Hospital, Jason Kwast and Ray Bajraktari. We are here today to determine the outcome on trial before the court on the matter between Mr. Stark, Dr. Lutze, and the West Valley Memorial Hospital. Both the plaintiff and the defendant's counsel will have 30 minutes each in total, 15 minutes each council member, to present their arguments to the court, including answering questions from the bench. The plaintiff will present their arguments first, followed by the defendants, and then a 3-minute rebuttal may follow by the plaintiff if they choose to do so. I will signal to the court when there is 5 minutes left per speaker. The court now invites counsel for the plaintiffs to begin.
Thank you. Hello and good morning, justices. My name is Hwang. I, along with my co-counsel Tanya Sleman, appear on behalf of the plaintiff, Mr. Sam Stark. Before moving to my argument, I remind the court of some notable facts at bar. This is the case regarding 29-year-old Kyla Stark, the plaintiff's wife, who neglectfully succumbed to her death at West Valley Memorial Hospital under the care of Dr. Lutzier. According to the FLCCC Alliance COVID-19 management protocol, there has been a relentless malpractice of physicians deliberately withholding effective early COVID treatments and of forcing the use of remdesivir in patients, which may have unnecessarily killed up to 500,000 patients in the United States alone. Although there were significant improvements in Ms. Stark's condition when administered with ivermectin, Dr. Lutzier withheld administration of ivermectin not once, but twice while she was admitted at his hospital. And when Dr. Lutzier exhausted the hospital's treatment plan, he neglected to pursue the reasonable standard of care that was undoubtedly required to save her life. It was during the most critical last 6 days of Ms. Stark's life, Dr. Lutzier finally admitted defeat and approved of her transfer. But at this point, it was too late. Justices, the case at bar today is one of many cases that shows what results when we allow physicians to continue their abuse of power in the field of medicine, where the archaic paternalistic policies and practice still used today blinds physicians towards the patient's best interest, setting a concerning precedent for the safety and autonomy of an individual who put their lives in the hands of doctors in Canada every single day. We, on behalf of the plaintiffs, submit that this case should be one that testifies that these negligent paternalistic practices should no longer be tolerated. Justices, today I will address to you the issue of standard of care. My co-counsel will address the issue of causation and vicarious liability. On the issue of standard of care, I have 3 points in my submission. In my first point, I will argue that Dr. Lutzier breached the requisite standard of care for failing to act with due diligence by failing his duty to consult the literature he was provided with. In my second point, I will argue that Dr. Lutzier's refusal to treat Ms. Stark with Math Plus or ivermectin breaches Dr. Lutzier's standard of care for failing to uphold his duty to refer. And finally, my third point will argue that the hospital standard of care to which Dr. Lutzier is responsible for was itself negligent. Before beginning my arguments, I submit to the court what constitutes the requisite standard of care for medical negligence. The requisite standard of care is one by which a jury can determine the parties responsible for the negligent conduct were the actions of a reasonable and prudent man. Reasonableness of this conduct is determined by the standard adopted in the community by persons of ordinary intelligence and prudence. When a medical practitioner declares himself as a specialist, a higher degree of skill is required and expected of that of a practitioner who does not impose such a claim. The court in Johnston versus Wellesley Hospital determined that although a professional's conduct is deemed reasonable when following the standard practice of their peers, it is not determinative. In my first point, we submit that Dr. Lutzier breached the requisite standard of care for failing to act with due diligence by failing his duty to consult the literature he was provided with. As supported by the court in Waters versus Hwang, a reasonable emergency physician would have looked at prior charting, lab reports, and any literature available to understand what has gone on. Dr. Lutzier does not satisfy this standard. We stress that the issue is not that Dr. Lutzier failed to read the literature sent to him by Dr. Strange, but that Dr. Lutzier failed to pursue further investigation at all, especially during the time he admitted to have exhausted all forms of treatment. Although a physician is not required to pursue all available literature, a reasonable one, when approached by a specialist of comparable skill, approaches him with literature pertaining a life-saving treatment in a time-sensitive circumstance, he would have acted with due diligence to investigate further. To further advance the first argument, in Norris versus LeBlanc, the court held that when a patient is worsening under the standard of care, a reasonable doctor has a positive duty to consult. This is further affirmed by one of the requirements that satisfies the duty to consult in Scott versus Moen, requirement number 2, which states, quote, "The patient is not responding to the treatment being given." Dr. Lutzier could have identified this to be the case on 2 occasions. First, on October 1st, when Ms. Stark was first treated under the hospital protocol, her condition worsened by the next day on October 6th, where she was moved to the ICU and placed on a nasal cannula during the day and BiPAP at night. And second, Ms. Stark was taken off ivermectin and returned back to the hospital protocol on October 7th, which caused Ms. Stark's condition to worsen the next day as she was sedated, intubated, and put on a ventilator. Dr. Lutzier did not only fail to review the literature, but was unaware of Ms. Stark's medical history or records at the hospital, which are all requirements affirmed by the Hwang case. In his disposition, Dr. L was unaware of Ms. Stark's treatment history in that he was unaware that Dr. Papadopoulos actually administered the hospital's protocol. Later in his disposition, he also used his false assumption of Ms. Stark's vaccination status as a reason why her condition was not improving, not knowing of her double vaccination status. Proceeding with my second argument, I will argue how Dr. Lutzier breached the standard of care by failing his duty to refer in a timely manner.
Can I just interrupt you briefly, Ms. Hwang?
Of course, Justice.
Would Dr. Lussier's standard of care not have been met by the research and diligence that he put into developing the treatment protocol in the first place? Is he obliged to re-research it for every patient who comes forward with a different demand for treatment?
Thank you for your question, Justice. To answer this question, I will advance straight to my third argument, which addresses this fully, which is that the plaintiffs raised that the two issues at hand was number one, in the circumstances that were given, Dr. Lutzier has exhausted all his treatment. He does not need to pursue further literature or a duty to consult necessarily when the standard of practice that is being administered by the hospital is working for the patient. But of course, in this situation, it was not the case. But the second largest issue is what we say in the third argument, which is that this hospital standard of care, which Dr. Lutzier created, was itself negligent practice, especially from stage 9 and forward, which is to turn up the ventilator and pray, to quote Dr. Lutzier, where in our position, the rightful conduct that was to be expected of a reasonable doctor in his position would have been for him to continue literature, pursuing literature, or pursuing his duty to refer. In the case of Waldick versus Malcolm, the court ruled that the conformity with standard of practice does not immunize a doctor from their negligent conduct when the standard practice itself is negligent. This creates an issue with the case at bar, as the standard practice that was used was created negligently under his leadership. Dr. Lutzier's administrative positions places him at a greater proximity and leverage to his responsibilities to uphold both the administration and creation of the standard of care at the hospital. One issue that arises from his power is his ability to have controlled what literature is deemed satisfactory without need or influence from his team. And satisfying an unreasonable standard of care that he himself created is negligent. In his disposition, Dr. Lutzier claims that his team is responsible for the hospital's COVID-19 treatment guidelines and that they only review high quality literature to be applied to those guidelines. However, in paragraph 443 of his discovery, when Dr. Lutzier is inquired about who is responsible for determining a quality of a study to satisfy this high quality requirement, he states that it is him who is able to make this determination. Dr. Lutzier makes no reference to a reliance on his team to make this judgment. Dr. Lutzier wrongfully asserted that there is no high quality study of ivermectin and ignored the administration of MAP+, even though there was affirmative research from the FDA, one of the agencies that he claimed his team relied on to create the standard. And further, the court in Terneuzen versus Korn raises that when a common standard is likely to result in danger, the practice itself could be determined to be negligent conduct. If the standard care at the hospital is to refuse ivermectin and MAP+ without having reasonable evidence that it is an effective treatment while a patient's critical condition is left to worsen, the standard fails to uphold the physician to act on behalf of the patient's best interest. And Dr. Moriarty, in paragraph 98 of his discovery, would also agree with this statement. He said that as physicians, they have a duty to adapt and treat their patients based on the best information out there, which gives them the leeway to prescribe off-label drugs and get creative. In the standard of care that was prescribed by Dr. Lutzier, this was not practiced by the hospital. Returning back to my second argument, I will argue how Dr. Lutzier breached the standard of care by failing his duty to refer in a timely manner. The issue that arises is, why did Dr. Lutzier only agree to transfer Ms. Stark on October 19th, a critical 6 days after he exhausted all his options? The court held in Scott versus Moen that the most critical factor in the duty to refer is timing. In Gillis State versus Marriott, the defendant was found to be negligent in failing to refer the patient in a timely fashion when the patient's condition was worsening under his care. The conduct of this defendant also accounted to his lack of urgency, an attitude that should have been reflective of a reasonable physician in his position. We submit that Dr. Lutzier is negligent for comparable reasons. It's incomprehensible that a deferral was not arranged in timely fashion, especially considering how from the administration of remdesivir on the 13th, Dr. Lutzier made no further efforts in finding alternative treatments for Ms. Stark. The court in Norris versus LeBlanc upheld a modified locality principle and held that if a doctor is able to easily access medical centers, they will utilize those centers when necessary. Dr. Strange physically came to West Valley Memorial Hospital on the 13th to assume care of Ms. Stark and was denied until 6 days later when it was too late. In the 6 days where Dr. Lutzier was in clear admittance that he has exhausted all relevant treatment, not only is this not the case, he was clearly aware that Dr. Strange was an accessible and determinate course of action. The 6-day delay that could have been a matter of life and death for Ms. Stark is a dire breach of the emphasis on timing set forth by the duty to refer. Dr. Strange accounts on paragraph 38 of her discovery that she has saved hundreds of patients who were placed in ventilators at the hands of other physicians, just as Ms. Stark has been on the 13th. Ms. Stark could have been saved if she was referred to Dr. Strange sooner. And
sorry to interrupt. Before you move away from the duty to refer,
yes.
the cases that you rely on in terms of the doctor's duty to refer, are they not applicable when the doctor referring is outside of his or her expertise, and therefore the duty requires that the doctor refer to a specialist? And if so, how does that apply to your argument when you said earlier on in your submissions that the Dr. Strange, that is, and Dr. Lutzier were of similar expertise?
Thank you for your question, Justice. To clarify, in Gillis State versus Marriott, the court stated that the duty to consult and the duty to refer is necessary when a physician satisfies one of 5 requirements. And the duty to refer does not only mean to transfer a patient from one hospital to another, but it could also mean to refer a patient to another doctor. And to satisfy that requirement, it's not necessarily that the physician has exhausted all his options, but it may also be the case that the physician himself is not well versed in the specific treatment that is requested of him from another physician. And Dr. Strange was a specialist with a comparable skill to Dr. Lutzier, and could have easily taken Dr. Strange, Ms. Stark, under her care. I apologize, but could you please restate the second part of your question?
I think you answered it, counsel. My question was whether the duty to refer applies when the 2 physicians in question are of similar qualifications or expertise.
Yes, it definitely does, Justice. The second requirement of the Scott case is what the plaintiff raises, which is that the physician, Dr. Lutzier in this case, has exhausted all his treatment, and his treatment seems to not work. And that is a satisfactory requirement for a physician to transfer another patient to another physician.
Thank you, counsel.
Thank you. In summary, Dr. Lutzier breached the requisite standard of care for failing to act with due diligence by failing his duty to consult the literature he was provided with. Dr. Lutzier's refusal to treat Ms. Stark with MAP plus or ivermectin breaches Dr. Lutzier's standard of care, failing to uphold his duty to refer. And finally, the hospital standard of care to which Dr. Lutzier is responsible for was itself negligent. Unless I may be of some further assistance to the court, this concluded my submissions. My co-counsel will continue our argument on the issue of causation and vicarious liability. Thank you, Justices.
Good morning, Justices. My name is Tanya Sleman, and I will be presenting the second and third issues of causation and vicarious liability. On the issue of causation, I plan on showing that Dr. Letzier caused the harm that was sustained by Ms. Stark. I have 2 points on my submission. The first establishes that by using the but-for test, the injury to the plaintiff would not have occurred, but for the negligent conduct of Dr. Letzier. The second establishes that causation need not be determined by scientific precision or experts, as sufficient evidence exists within the case to constitute an inference of causation. Thus, causation is a practical question of fact that should be determined by ordinary common sense. On the issue of vicarious liability, I will be arguing that West Valley Memorial Hospital should be held vicariously liable for the negligent actions of Dr. Letzier. I have 2 points on my submission. The first illustrating that Dr. Letzier and the hospital had a direct employer-employee relationship, as he was not only a physician at the hospital, but also the chief of the hospital and medical director of the emergency department at the time that he was treating Ms. Stark. My second point highlights that the negligent actions in question occurred during the scope of his employment at the hospital. Moving on to the arguments for the second issue of causality, it can be said that causation is determined by a balance of probabilities where the plaintiff establishes that the defendant caused or contributed to the injury. As established in Snell v. Farrell, the test used to determine causation is the but-for test, which states that the injury to the plaintiff would not have occurred but for the negligent conduct of the defendant, Dr. Letzier, Dr. Letzier ought to have known or knew that supportive treatment he was providing Ms. Stark, especially in the last 6 days of her stay at the hospital, was ineffective. He was negligent in disregarding Ms. Stark's vaccine record and medical history. He ought to have consulted Ms. Stark's medical record, in which it would have been evident that remdesivir had not worked on Ms. Stark and that he had exhausted all other treatment options except for MAF plus and ivermectin. Furthermore, his lack of collaboration and refusal to refer to material sent by Dr. Strange make it highly probable that the harm that befell Ms. Stark would not have occurred but for Dr. Letzier's neglectful actions. His lack of referral meant that he did not resort to any remaining treatment options and thus did not administer MAF plus protocol or ivermectin when he should have. The standard of care as highlighted by my co-counsel includes the duty to consult, which requires the physician reflects on all available literature, and in cases where all possible treatments have been exhausted, a duty to refer in a timely fashion. Had Dr. Letzier adhered to the standard of care and performed the due diligence expected of a physician in this position, it is reasonable to assume that absent his own biases against ivermectin use, Dr. Strange's documents and Dr. Strange herself would have encouraged Dr. Letzier to administer MAF plus protocol and ivermectin as a last resort. Dr. Letzier's lack of adherence to his duty to refer during the last 6 days of Ms. Stark's life ultimately led to her demise. This is further highlighted as Dr. Strange stated that she had been able to nurse many individuals in the same condition as Ms. Stark, namely on a ventilator with low chances of survival, back to health after administering MAF plus and ivermectin during the same stage of illness, and both she and Dr. Titchener saw no side effects, including death or injury, when they treated their patients with ivermectin. Additionally, within the FLCCC's 87 study meta-analysis, it was found that 27 randomized control studies, which included 3,400 patients, all showed a reduced mortality rate and hastened recovery when provided with the protocol of MAF plus protocol and ivermectin. It is highly unlikely that Dr. Letzier provided Ms. Stark with It is highly unlikely that had Dr. Letzier provided Ms. Stark with MAF plus and ivermectin protocol, that she would have succumbed to her illness. Finally, given the circumstances of COVID-19, the lack of hospital visitation at the time of Ms. Stark's stay, Dr. Letzier's duty to consult with the family was heightened and also neglected. If not for Dr. Letzier's actions and his lack of adherence to proper standard of care, Ms. Stark would not have succumbed to her illness. As seen in the case of Afi versus Leonati, causation need not be determined by scientific precision. Under certain circumstances in which evidence is sufficient to constitute an inference of causation, there is no need for scientific proof. The defendant's negligence need not be the sole cause of injury. Rather, causation would be a practical question of fact determined using ordinary common sense. So long as it can be shown that the defendant's conduct caused part of the injury, the defendant is liable for the injury. As stated above, the actions performed by the defendant need not be examined with scientific precision, as they alone are enough to have ordinary common sense determine cause. On a balance of probabilities, without the need for scientific precision, Dr. Lutzier's negligence was a breach of the reasonable standard of care and the cause of Ms. Stark's declining condition, if not her death. On the issue of vicarious liability, to establish that West Valley Memorial Hospital is vicariously liable for negligent acts of Dr. Lutzier, it must first be established that the acts committed were negligent, that he had an employer-employee relationship with the hospital at the time that he was treating Ms. Stark, and that he committed the negligent act while under the employment of West Valley Memorial Hospital. As a Justice, I believe, yes.
Thank you. Will you be returning to causation? If not, I have a question before you move on to vicarious liability.
I will not be returning. Please go ahead
All right.
with your question.
Thank you. Counsel, what do you say about the defendant's argument that there is plenty of literature out there, including the Health Canada, for example, that says that the treatment that you say ought to have been provided would not have been effective? So how do you deal with that evidence when you say that the evidence on a balance of probabilities suggests that that causation is met in this case?
While there is some evidence on that side of the spectrum, there's also a lot of evidence on the side of our spectrum that states that ivermectin would have been a good treatment, and also ivermectin and Math Plus were both FDA approved at the time that Ms. Stark was receiving the treatment. And Dr. Lutzier states several times that he looks at the FDA, he looks at several other organizations, and if he had looked at the FDA at the time that he was treating her, he would have known that the FDA had approved of both ivermectin and Math Plus at the time that she was receiving her treatment. I hope that that answers your question, Justice, and if not, I'm available for any further questions.
Do the plaintiffs rely on the fact or as evidence that Ms. Stark appeared to be improving when the medication that you say ought to have been administered was administered? Is that part of the evidence the plaintiffs rely upon?
Yes, it is.
Okay, thank you.
As well as our secondary sources. To continue, West Valley Memorial Hospital, as established by my co-counsel and I, Dr. Lutzier acted negligently when he breached a standard of care which resulted in him causing the harm that befell Ms. Stark. In turn, his employee relationship with the hospital and when the negligent act was committed are now being examined. Given that Dr. Lutzier signed a contract with the hospital on February 11, 2016, which appointed him as the chief of West Valley Memorial Hospital and its director of the director of the medical emergency department, it can be said that he was not only working within the hospital in the capacity as a physician, but also that he was directly employed to serve within an administrative capacity. Within his administrative roles, which fall under the Ontario Hospitals Act rather than the Medicines Act, the preventing of negligence in that field would be the responsibility of the hospital. Thus, West Valley Memorial Hospital is vicariously liable for the actions of Dr. Lutzier. This is furthered by the fact that he was employed by the hospital at the time where the negligence occurred as per Huberman. To conclude, Dr. Lutzier breached his standard of care, caused the harm that was sustained by Ms. Stark, and thus West Valley Memorial Hospital was vicariously liable for Dr. Lutzier's actions, as the negligent act occurred when he was employed by the hospital. The court should consider the life that Ms. Stark lost, and more importantly, the countless other patients that Dr. Lutzier will treat in the future who may also encounter the same negligent actions unwittingly. At this time, we seek damages, costs, and such further and other relief as this honorable court deems just, and in order for the College of Physicians and Surgeons of Ontario to further investigate Dr. Lutzier's conduct under the Medicine Act. Unless I may be of further assistance to the court, these are my submissions. Thank you.
The court now invites counsel for the defendant to begin.
Thank you. Thank you, Ms. Moderator. Good morning, honorable justices. First of all, please pardon my appearance. I'm not usually this translucent. My name is Bajraktari, and I am here with my colleague, Jason Kwast, as counsel for the defendant, Dr. Justin Lutzier, as well as West Valley Memorial Hospital in the matter of Stark v. Lutzier 2022 ONSC case file 2821. Now, we are aware that you have a particularly filled docket today, so we will be as concise as we can. But first and foremost, we want to draw a roadmap for you today that will highlight our key items in our submission. First of all, I will be providing a brief overview of the key issues in this case as we have gone over the facts in detail. Following that, I will jump straight into my arguments pertaining into standard of care, as well as allocate some time to responding some points raised by opposing counsel in their written submissions regarding standard of care. I will then pass it on to my co-counsel, Jason Kwast, to take you through causation and vicarious liability, as well as having time dedicated in his oral submissions to respond to opposing counsel on both matters. And finally, he will leave the court with some final considerations, as well as our order sought on behalf of the defendant. So first and foremost, the main issues at hand today are the following. The first being whether Dr. Lutzier breached the standard of care for medical professionals regarding his patient, Ms. Kyla Stark. The second being whether Dr. Lutzier's actions or inactions caused the death of Ms. Stark. And lastly, whether West Valley Memorial Hospital can be held vicariously liable for the above two matters if they are found to be in the affirmative. Honorable justices, we want to make it clear today that we strongly reject the notion that Dr. Lutzier is liable for causing the harm incurred by Ms. Stark and for a breach of care on this matter. We also further reject that the hospital should be held vicariously liable because we respectfully argue before this court today that you should find no tortious wrongdoing in Dr. Lutzier. Without further ado, I will now dive into my arguments, starting with standard of care. So the appropriate standard of care for medical professionals derived from the Ternuizen v. Korn case is that of a reasonably prudent and diligent medical professional in the same field. Johnston v. Wellesley Hospital clarified the standard by saying that it is not one of perfection, it is one of reasonableness. Furthermore, the standard is measured on a relative basis between competent and comparable professionals or specialists in the same field, as was ruled in Natras v. Weber. Courts in the past have been highly deferential towards physicians regarding the standard. See the Cram v. Ostreicher case. And in the case of disagreement regarding a particular medical treatment between professionals, the Supreme Court decision of Wilson v. Swanson states that a physician's action or inaction can be considered an error of judgment rather than a breach of the standard of care if there is substantial opinion among medical professionals that can confirm the physician's treatment. Now, prior to the hearing today, we have provided the court numerous sources in our written submissions from several reputable medical journals, such as the National Library of Medicine, the JAMA Network, the BMJ, and Springer, to name a few, that prove that there is indeed substantial medical opinion advocating against the use of ivermectin and MAP+ in treating COVID-19. I do want to make a point of clarification here that today our points will center around ivermectin and its use specifically for COVID-19, not as a drug in its standalone form to treat its on-label prescription needs. Furthermore, in regards to the evidence surrounding MAP+ and ivermectin, we need not look further than the testimony of Dr. Moriarty in this case to see that there are in fact medical professionals that would argue against using ivermectin and MAP+ for COVID-19. Now, should tomorrow or any time in the immediate future, should the world rule that ivermectin and MAP+ be considered effective COVID-19 treatments, well, then we ask the court to look at Dr. Lutzier's action as an error of judgment rather than negligent. But as I will highlight further, and as my colleague will continue to emphasize, we do not believe that ivermectin and MAP+ are indeed effective treatments due to how fiercely they are debated in the medical community. And so it would be incorrect then, as such, given the polarizing views, to consider them to be effective courses of treatment now and at the time of treatment when Dr. Lutzier was acting as physician for Ms. Kyla Stark. So with this in mind, then, we ask the court to not regard Dr. Lutzier's actions as negligent because he was operating upon practices which are supported by substantial professional opinion in the medical community. Moving on now to the topic of Dr. Lutzier choosing not to read the materials forwarded to him by Dr. Strange, we respectfully argue before this court today that he was not compelled to read these materials in light of the substantial opinion, as I stated before, that can support his professional course of action. Now, we do not have direct evidence of Dr. Lutzier relying on the exact studies we forwarded in our written submissions, but we do, however, argue that the court make the reasonable inference that Dr. Lutzier, having consulted as many references as he did when crafting the hospital's policy, reminding the court that he ballparked at around 100 references, his evidence-based medicine approach, which favors highly reputable sources above all else, and his willingness to update the policy as the pandemic evolves, that we make the reasonable inference that he would likely have encountered equivalent research in his practice which has caused his staunch opinion regarding ivermectin and math plus based on said research. As we mentioned in our written submissions, Dr. Moriarty's testimony can inform the standard of care because of jurisprudence that has been highly deferential to medical professionals in the past. As I stated before, Cram v. Ostreicher is an example of that jurisprudence. Dr. Moriarty stated in her testimony that a physician who chooses not to read studies or meta-analysis provided from another professional would not be negligent in doing so if they either knew about the studies or could refute such a study. Now, given Dr. Lutzier's proximity and expertise on this particular matter, we want to remind the court that he is a pulmonary physician and that he does have specialty in critical care. It can be reasonably inferred that he has indeed encountered such studies that refute the efficacy of ivermectin and math plus, and thus was not compelled to consult Dr. Strange's materials.
Counsel, before you go on.
Yes.
You're asking this court to make an inference. Is that because we don't have any direct evidence from Dr. Lutzier as to whether or not he was aware of such studies that say the things that you say they would have said?
Thank you, Your Honor, for your question. I am asking the court to make this inference because in Dr. Lutzier's discovery materials, he only alludes or vaguely refers to. This is likely due to the fact that he has seen so much material in the past that it's hard for him to draw upon exactly what he has been reading. But we are asking this inference because of that lack of direct evidence. That's right.
Thank you.
Okay.
If
Now,
I
yes.
could just pick up on that, sorry, was there any
Sure.
evidence as to whether or not the treatment protocol at West Valley Hospital differed in any significant way from similar protocols at other hospitals in the same jurisdiction at the same time?
Thank you, Your Honor, for your question. I do not believe there was any evidence of that nature. I'm happy to refer back to the materials and get back to you on that, but off the top of my head, I do not believe there was evidence of such nature.
Would you agree that such evidence would be of relevance as to whether or not the hospital itself would be vicariously liable if the treatment was determined to be unsuitable in the circumstances?
I do believe that it would be of consideration. However, as my colleague will mention in his analysis of vicarious liability, it would not be definitive, given the fact that the policy that was crafted by Dr. Lutzier, we do believe to be one that was effective given how frequently it was updated and given how the amount of references that he used in crafting it, as well as its proven efficacy in the past. So in regards to other hospital policies, I definitely think it would be worth noting and looking into, but we do not believe it to be definitive. Okay, thank you. Before moving into some points regarding opposing counsel's points that we would like to respond to, I do want to make a quick policy point before the court today that if we are to ask doctors to take on new treatments without regard for there being fierce disagreement in the medical community regarding this particular treatment, and then further compelling them to administer it, even if it goes against their own duties to be prudent, it would chip away at the integrity of the standard of care and would require physicians to administer treatments when the jury is still out on their efficacy and safety. So from a policy angle, we do not believe Dr. Lutzier should be compelled to administer ivermectin or MAP+, given how first of all, there is no medical consensus, and second of all, the views regarding these particular treatments are so polarizing that compelling him to go forward with this would just open the floodgates for further issues for physicians in the future. Now, a quick response to a point made by opposing counsel. I want to turn the court's attention to paragraph 30 of opposing counsel's written submissions. Opposing counsel here argues that ivermectin and MAP+ are, quote, reasonable alternatives, quote, and they're referring to the course of treatment. We reject this notion because as of right now, the medical literature regarding ivermectin and MAP+ are, as I mentioned before, polarizing, and there is very little agreement on its safety and efficacy when used to treat COVID-19. Organizations such as the WHO and the FDA, which opposing counsel mentioned before, do advocate for ivermectin, but should take a quick look at their website currently, as they recommend against its use for COVID-19 specifically, namely because of how it interacts with blood thinners, including Advil, which is very common. A key article that was used to support the MAP+ protocol, written by Pierre Corey, was retracted by the Journal of Intensive Care Medicine because it relied on inaccurate mortality rates. Now, these are just a few examples here that speak on how these courses of treatment are still very much so experimental. And to circle back to the WHO and the FDA for a moment, they consult countless healthcare experts and opinions when making their recommendations. And as of the date of this hearing, they do not consider ivermectin to be a reasonable course of treatment, yet opposing counsel would insist otherwise. They rely on materials forwarded by Dr. Strange, which, to paraphrase Dr. Lutzier, and you can cross-reference to paragraph 222 of his discovery, these materials forwarded to him are not of highest merit. We advance the point that given the high level of contention surrounding ivermectin and MAP+, that we cannot refer to them as reasonable alternatives as opposing counsel suggests. So barring any further questions from the bench, I would now like to pass it on to my colleague, Jason Kwast, as he will elaborate further on our points in causation and vicarious liability.
Good morning, Justices. I am going to speak on causation and vicarious liability, as my co-counsel stated. The position of the defense is that even if the actions of Dr. Lutzier are found to be negligent, his negligence did not cause nor contribute to the harm or injury of Mrs. Stark. This is because the action fails the but-for test. The but-for test is the well-established test for proving causation. As stated in the Supreme Court of Canada, as stated by the Supreme Court of Canada in Clements and Clements, it requires that the plaintiff prove that but for the negligent acts of the defendant, the plaintiff would not have suffered the harm or injury that they did. The Supreme Court also clarified that the but-for test is up to the task of resolving causation in medical malpractice cases. It stated that when one remembers that causation need not be determined by scientific precision and requires the exercise of ordinary common sense, the but-for test is sufficient. Causation cannot be made out because there are two potential causes, and it is impossible to know which one caused the deterioration in Mrs. Stark's condition. We know that when Dr. Lutzier stopped the administration of ivermectin on October 7th and stopped MAP+ protocol on October 13th, Mrs. Stark's condition deteriorated. However, this correlation could have been caused by Dr. Lutzier's changing treatments, or it could have been caused by her COVID-19 infection, regardless of the treatment she was placed on. We cannot know for sure which potential cause was the correct one. The defense argues that for this reason alone, causation cannot be proven on a balance of probabilities. Dr. Lutzier was replacing two unproven treatment courses, ivermectin and MAP+, with a proven treatment course, supportive care. If her body had been responding to treatment, supportive care would likely have improved her condition as well. That her condition did not improve under proven treatment suggests that her body would not respond to any treatment. Thus, on a balance of probabilities, the facts suggest an inference that COVID-19 was the cause of her deterioration, not the acts of Dr. Lutzier. In the alternative, it's open to the court to draw an adverse inference against Dr. Lutzier. However, such a move is optional. The court would also be entirely correct to choose not to draw this inference. Here, it would require the defense to produce evidence that the defendant's doctor's actions were the true cause and not COVID-19. This inference would be rebutted by the evidence of the FDA, CDC, Health Canada, Dr. Moriarty, and Dr. Lutzier, among others. None of these organizations or individuals support the use of ivermectin and math plus in treating COVID-19. This evidence is sufficient to extinguish an adverse inference of causation. Needless to say, these organizations are made up of many doctors and other healthcare professionals. It's easy to feel that the expert evidence here is conflicting and taken together inconclusive. But when we remember that hundreds, if not thousands of doctors make up these organizations and they all agree not to recommend ivermectin and math plus as COVID-19 treatments, the evidence supporting such treatment from two individual doctors, Dr. Strange and Dr. Titchener, as well as a few isolated studies, can be seen for what they really are: a small minority dissent against the broader consensus that opposes the use of ivermectin and math plus as COVID-19 treatments. Finally, it's worth noting that finding Dr. Lenczner to have caused harm or injury to Mrs. Stark by failing to administer ivermectin or math plus would result in negative public policy outcomes. Specifically, it would result in the vast majority of doctors across Canada being found liable for failing to institute these treatments. Even if ivermectin and math plus were proven to be effective, one cannot expect every doctor to immediately be made aware of this and institute it when major public health organizations such as the CDC and Health Canada do not say it is appropriate to do so. There may be some studies. Yes?
What do you say about the plaintiff's argument that this is really a case of last resort? So when it became obvious that the treatment protocol that Dr. Lenczner was using was ineffective, and it appeared that Ms. Stark, her chances of surviving were quite low, why not at that point, given what you have said about the experimental nature of the treatment, of the fact that some organizations don't agree? But what do you say about at that point, there was a duty to try this treatment when all other remedies had been exhausted?
Well, to put it simply, an unproven treatment, it just wouldn't make sense to use an unproven treatment at any point. You can also, what's the word I'm looking for? Provide treatment by giving vitamin C or vitamin A, but we know that there's no evidence to suggest that that is going to help a COVID patient that's deteriorating. Similarly, ivermectin and math plus, it's not proven, and therefore there's no point in administering at any point treatments that are unproven.
Thank you, Council.
Even if ivermectin and math plus were proven to be effective, yeah, like I said, there may be some studies which suggest that treatments may be effective, but even if they're proven correct, it's not unreasonable to say that it's too early to know whether these treatments are truly effective against COVID-19. This is what the major public health organizations have said. Moving on to the issue of vicarious liability. The defense does not dispute that Dr. Lenczner is an employee of the hospital. However, if the court finds that he acted negligently, then Dr. Lenczner was acting outside of the scope of his employment. This is because his employment contract requires that he act within the, quote, standards of practice and care, end quote. Thus, the hospital cannot be found liable for Dr. Lenczner's actions. To provide some context for the law on this issue, in most situations, the hospital is not liable for the actions of its doctors. Liability is avoided because doctors are normally considered independent contractors instead. In Yepremian and Scarborough General Hospital, the leading case on the subject, it was also noted that there is no duty of care owed by a hospital to a patient in Canada. Thus, it could only be liable by vicarious liability. However, in Yepremian, the Ontario Court of Appeal clarified that part of the reason the law is set up this way is that it's fair and reasonable for the highly skilled doctor who made the negligent error to have to pay for it, not the hospital. It emphasized the importance of the high level of expertise that all doctors have in commonly apportioning liability to them and not the hospitals. In other words, the principle on which this decision was based was that doctors have a high level of expertise, so should be the ones bearing responsibility when they act negligently. The caveat, of course, is that employers are liable for the actions of their employees, and Dr. Letzier is an employee. So how do we get around this? If Dr. Letzier is found to be negligent, then he will have betrayed the confidence the hospital placed in him with his high level of expertise. This context helps us to better understand the exact wording of Dr. Letzier's employment contract. It requires that, in line with his expertise, Dr. Letzier must, quote, render services to hospital patients in a competent, professional, and ethical manner at all times and in accordance with the current and prevailing medical standards of practice and care, end quote. Note the language at the end of the quote, at all times and in accordance with the current standard, practice, and care.
Can I interrupt for a question, counsel?
Please, yes.
It seems to me that what you're arguing is that if the doctor was not negligent, i.e. maintained the standards of practice, then obviously the hospital is not vicariously liable.
Mhm.
However, if the physician did not act within the standards of practice, also the hospital is not vicariously liable because he acted outside of the standard. How does that protect patients who come to harm in hospitals from a policy perspective? It seems like you're arguing that the hospital could never be vicariously liable for the negligence of any employee, whether they're physicians or otherwise.
Well, firstly, I believe that it's different when they're physicians than in another position, such as a nurse or an orderly, because physicians have that high level of expertise. And from a public policy perspective, a hospital is completely reasonable to expect that the doctor knows what they're doing and won't act negligently. Therefore, it's our position that from a public policy perspective, it's not reasonable to hold a hospital liable for the mistakes of the doctor given their level of expertise. The justice towards the patient, to your point, is that they will receive compensation in the appropriate cases directly from the doctor or their liability insurance, but not the hospital. So they would still be compensated, but simply through the doctor and not through the hospital itself. Thus, if Dr. Letzier acted outside of the standard of care, he acted outside of his employment mandate with the hospital. In other words, the hospital cannot be held liable for the negligence of Dr. Letzier, as only the actions that Dr. Letzier performs, which meets the standard of care, are within the scope of his employment contract with the hospital. This concludes the submissions of the defense. The counsel for the defense respectfully requests that the court issue the following. Firstly, that it finds Dr. Letzier did not breach the standard of care. Secondly, that he did not cause the harm or injury afforded to Mrs. Stark. Thirdly, that if Dr. Letzier is found negligent and his negligence is found to have caused injury to Mrs. Stark, that the hospital not be found vicariously liable for Dr. Letzier's actions. Finally, we asked for costs to be granted. Thank you.
Okay, the court now invites the counsel for plaintiffs to begin the rebuttal.
Thank you, moderator. Our friends in the opposing counsel relies on the evidence that the general medical community would agree to the standard of care and this somehow immunize Dr. Letzier to pursue further literature. This is an unjust statement. Firstly, justices and friends, Dr. Letzier himself can account for the rapidly changing turbulence of the developments of the medical community in the time of a global pandemic. If treatments and courses of action did not change so rapidly during this time, Dr. Letzier and his team would not update literature monthly to account for these rapid changes. Then why is it that Dr. Letzier said this? I would like to direct our justices and our friends in the opposing counsel to paragraph 493 of Dr. Letzier's disposition. When given a parallel scenario to the facts at bar, Dr. Letzier claimed in his discovery in the case that where a plaintiff when a patient's condition is deteriorating and the physician has exhausted all treatments and a colleague in the respected field sends the physician literature regarding a life-saving treatment that could aid the patient, his duty as a medical specialist would be to engage in a formal discussion with his colleague and read what they had sent him. Although the facts at bar are parallel to that of this hypothetical scenario, Dr. Lenczner neglected in his own terms his duty to consult Dr. Strange and read the literature that was sent to him. In addressing Justice Jarvis's inquiry of whether or not the West Valley Memorial Hospital's treatment differed with treatment from other hospitals' policies, our friends of the opposing counsel raised that the differences were not determinative. This is a blatantly false remark. The hospital's COVID treatment plan is much more invasive than administering ivermectin and Math Plus. We would like to refer you to the reasons why, which is that at the hospital had a code blue with a patient who was administered with the hospital's COVID-19 protocol. This patient sedation drug ran out completely, causing the patient to wake up and break the feeding tube, causing food particles to escape from his lungs, resulting in aspiration, which ultimately led to infection after infection. Whereas Ms. Stark, treating COVID patients with ivermectin and Math Plus, not a single injury, not a single death. And this is a concern, especially because intubating a patient and using invasive medical ventilation is invasive and much riskier to use on a patient administered to the ICU than the no-risk Math Plus protocol. Furthermore, our friends in the opposing counsel claim that the efficacy of ivermectin and Math Plus cannot be proven. Firstly, we stress to the justices, regardless of the statement, it's refutable that Dr. Lenczner refused to investigate to nearly determine whether ivermectin is ineffective, to rule it out completely. Second, I direct the court to some statistics. Firstly, it is that the WHO approved of remdesivir only after one study of 1,776 patients with 17% improvement, compared to ivermectin, which was 64 studies, 48,637 patients with 66% improvement, but still yet hasn't been approved by the WHO. This is a statistic that we would like the justices to consider when making their decision. Lastly, friends of the opposing counsel stated that it is wrongful to connect Dr. Lenczner's administrative position to the hospital. I see that my 3-minute mark has elapsed. Thank you, justices, for your time. That concludes our rebuttal.
This concludes the matter of Stark v. Lutzier.